Thank you for joining us for this month's YANA webinar on nonprofit leaders' fiduciary duties, an important topic that anybody who works in nonprofit industry, particularly on boards, governance, lawyers, leaders, something you just need to know a lot about, and we have some experts joining us. My name is Rachel Littman, Yale College class of 1991. I'm the Executive Director of YANA. Our panelists today are Matt Gelfand, class of 77. He's Managing Director at Moreland Associates, and joining him are his colleagues, Richard Moreland, he's the founder and CEO of Moreland Associates, as well as Robert Scott, who's Senior Advisor to Moreland Associates, and he's also President Emeritus and Professor Emeritus at Adelphi University. Before I officially start the webinar and hand it over to our speakers, I just wanted to cover a few logistics. Just to remind everyone, like all of our programs, this session is being recorded. It will be cleaned up and made available in video, and we now also have the ability to strip out the audio in a podcast form. They will be archived on our YouTube and Buzzsprout channels, and as we normally do within a few days of the event, we'll send a registrants showing you where that link is so you can view it at any time. If you forget, you can always go back to the YANA website, which is yana.community is our short code. That will get you to our site, and you can find us through there on webinars. You can see all of our past webinars, including write-ups and links back to the YouTube channel where the videos are archived. The slide deck, our speakers have graciously agreed to make available, but as per our policy, that will only get sent to registrants who are current YANA members, and that means those who have donated at least a minimum $60 a year in the past year. So if you really want to get a copy of this, please join YANA now if you haven't done so. We will allocate time at the end for Q&A, and you'll be able to speak or direct questions directly to the panelists. In the meantime, I will be sitting in the sidelines monitoring the Q&A and the chat function, so you can post questions there. If there's anything particularly urgent, I will try to interrupt the speakers. Otherwise, we will let them proceed with all the information they have to offer us. So without further ado, I'm going to put myself on mute and hand it over. I just want to make sure I have the right screen share here, and hand it over to Matt. And Matt, you can take it away. Thank you very much.
Thank you, Rachel. And thanks to everyone who's on the webinar today for spending time with us. We really appreciate your attention. I'm going to start with a little bit of biographical information about my colleagues and myself. And as I'm introducing our colleagues, I'll give you a little bit of the lay of the land of what we'll be talking about specifically. So we're going to lead off with Bob Scott, who, as Rachel said, is the President Emeritus and Professor Emeritus at Adelphi University and Ramapo College of New Jersey. He has an illustrious career. I won't go through all of it in the interest of time, but highlight a few points about all of us to give you a sense of our backgrounds in the nonprofit world. In addition to his official status at 2 different universities, Bob was also a visiting fellow at the University of Oxford, a scholar at the New York Public Library, and he is the author of the recently published book, How University Boards Work, which won a prize called the Eric Hoffer Book Award last year. So he is literally authority on the subject that we're talking about today. Bob will, let me go to the next page here. If I can, there, one's too far. Bob will talk about the overview of governance in general of nonprofit organizations, and then I will talk specifically about something called MIFA, the Uniform Prudent Management of Investment Funds Act, which governs investments of nonprofit organizations of all kinds. By way of background, I'm an economist by training.
Matt, excuse me, the audio is not clear. And I don't know whether that's, and actually there's a note in the chat from somebody saying the same thing.
There's not a whole lot I can do about it. Perhaps
Well, that's
if
fine. No, you're fine.
Closer to the screen, because my mic is built into my screen. As I was starting to say about my own background, in terms of nonprofit work, I've been working in the investment industry for about 30 years, and all of that time I've had nonprofit clients of a wide variety as clients. Every year that I've been in the industry, I also have served on investment committees for a 501c3 charity and on the investment committee of a private foundation. And I've done both of those for on the order of 15 years. And finally, Rich Moreland is going to talk about a specific topic within investments, the investment policy statement. And we'll talk about what that means in a little while. Rich also has a 30-year career in the financial industry, directly or indirectly. For purposes of this audience, I'll just highlight that he was the assistant treasurer at National Geographic Society for a number of years, a former trustee of the Notre Dame of Maryland University, as well as a trustee of the Maryland Historical Society and several other nonprofit organizations. So I'll leave the introductions at that and hand it over to Bob Scott.
Thanks very much, Matt. Thank you, Rachel. Thanks for everyone for being here. While my work and writing and consulting is mostly in higher education, the principles of governance that I'll outline apply also to other nonprofit organizations and for-profit. My starting point is that governance is an important part of leadership, which means that the composition of the board is critical. It is interesting to note that under 10% of the trustees at American colleges and universities have any professional experience in the enterprise. It's hard to imagine Chase or Google declaring that 90% of their directors have no experience in the industry. But that is the case in higher education, and it's also often the case at many nonprofits because of the focus on fundraising. So we'll get to more about composition. The governance comes in three modes. First, the fiduciary, the boards being stewards of tangible assets. Strategic, that is boards as partners in monitoring progress on a strategic plan. And what is called generative, boards that are sufficiently engaged that they actually engage in sense making, understanding the operations and participating fully. As stewards, they are responsible for all aspects of the enterprise and have the traditional board duties of care and loyalty. You can go to the next slide. Care and loyalty, but also an extra duty of obedience. The duty of care requires the level of competence, the degree of diligence one would expect of a prudent person fulfilling the assignment. The duty of loyalty requires that the director or trustee operate in good faith and in the best interests of the organization, not out of self-interest. This is often the area where we get into conflicts of interest. The duty of obedience requires that board member actions must be true to the charter and mission of the organization. It is this duty that relates then to the level of trust the public expects of a director. It also requires that the director have many sources of information, not just from the CEO, because we're often likely to focus on the good news, and we need to have a civil conversation about the challenges. Next slide. Bylaws can be boring or appear to be boring, but they're actually the basic building blocks. The name of the organization, think in terms of a trademark and distinctiveness, purpose, the mission. Mission is critical because that is what is approved for universities and nonprofits, approved by state charter, and have to be the touchstone in planning. Membership, as I just said about membership on university boards. Boards should use a matrix of talents and experiences desired and what current members contribute in terms of characteristics and experience, not just money. I always wanted to have a faculty member, senior faculty member from another university on my board, because while I know higher education, an equal standing board member as an academic can stand up to you guys in finance who often don't take an academic perspective. Officers and elections. What is the process for removal of someone, not only for election? And I've had occasion to have to engage in removing a director, not an easy or pleasant task. Meetings. These days, many meetings take place by Zoom or conference call. But bylaws have to spell out the parameters and limitations on the use of technology, especially the recording of minutes, quorum requirements. There's nothing like having a board meeting, whether a Zoom or a teleconference, and hearing dishes being washed and dogs barking. You need to spell out the requirements. Committees. There should be a charter for each of the committee, the number of members, what the requirements are. Certainly in a finance committee, someone who understands finances. Parliamentary authority. What are the rules of the road? Most people use Robert's rules, specifying how amendments are introduced and voted on. And then, of course, a conflict of interest policy, spelling out how trustees and directors should avoid conflicts and the reporting requirements. Next. Next slide. Thanks. I'm going quickly. We'll have time for Q&A after it. This is a model board meeting agenda. In order to have efficient and effective meetings and to make sure there's opportunity for everyone to participate, the chair of the board and the president or executive director, CEO, have to have a template. Well, there's the roll call, the approval of the minutes, motion to enter into executive session where all but the trustees and presidents leave. And it's important, and I've been on a board where it turned out that the executive session meetings were being recorded so that the staff person could create minutes. Well, that's a no-no. The president and the board chair can agree upon minutes because these are often related to personnel issues and you don't want them available under depositions. Approval of the minutes of the previous session, the board member comments, the confidential president's report. This is an opportunity for a president or executive director to report on any and all topics, strategic, personnel, with the board alone. Then the trustees meet in executive session alone or perhaps with selected advisors like legal counsel without the president or executive director. It's best to have that as standard practice so that when it is necessary for the board to evaluate the president, it's already had a precedent that, yes, we meet without you. The next agenda, oh, that's it. Then you can see these motion to exit executive session, the board chair's comments in public, the president's comments in public. I've always wanted, and I learned from a former trustee of mine who was very prominent actually in the securities field, who suggested that we organize the agenda into 3 categories of decision items, discussion items, and often discussion items are preparation for a future decision, and information items. And then for each of those, to have a particular template. What's the background for the discussion, for the decision? What are the alternatives considered? What's an assessment of the pros and cons, the recommendation? What are possible implications? What are possible unintended consequences? Don't we wish that the board at Facebook had talked about unintended consequences early on? And then there's always a good idea to have a major discussion topic, which I've indicated here, and then adjourn. The next, board orientation and continuing education. If people don't know about the quote industry or enterprise, they've got to be educated. Monitoring milestones. I always think in terms of monitoring the alignment of mission. Remember we talked about mission or purpose, vision, goals, strategies, environmental scan, resource allocations, rewards, results, and reflection. Now, monitoring. In higher education today, I would argue that there is a big disconnect in terms of the alignment of mission and rewards. Colleges say their mission is teaching and educating students. The major reward they give to faculty beyond compensation is release from teaching and substituting in part-time. And while many part-time faculty are great, they should not be the main faculty of an institution. So there's a disconnect there, and the big result is a very inadequate graduation rates. Performance reviews of the board and the executive each year, including the performance review of the whole board, the board chair, relationship between the board chair and the board, and the executive. And then succession planning for the board, as well as board leadership and the leadership of the organization. Next. Conflicts of interest and potential consequences. There are many too many examples. And for example, well, when I came to Adelphi University in the year 2000, I was the 6th president in 3.5 years. And there had been many conflicts of interest on the board. The board was removed of a private institution, and I came in. I was a consultant to a college last year talking about the purchase of debt. They had borrowed a lot of money for facilities. They couldn't pay it. The students didn't come. 2 board members set up a private company and purchased the college's debt, or half of the college's debt, at a discount, a no-no. Another college I was consulting with this past year borrowed a very large amount of money from its endowment. That too is a no-no. You can borrow from the unrestricted part, but not the restricted part. The conflict of interest form should indicate whether any of the directors or trustees are engaged in business with others on the board. So in conclusion, being on a governing board is an act of commitment and of leadership. And when it works well in partnership with the executive director, the president, and CEO, it can be a marvelous, constructive experience. But it does require preparation, participation, and active engagement. Thank you.
Thanks, Bob. I am now going to talk about a specific topic within fiduciary duties covering investments. And this arena is governed by what's called UPMIFA, the Uniform Prudent Management of Institutional Funds Act. That's a mouthful, so we'll go with UPMIFA for the remainder of the session. If you want to learn more in detail about this law, you can see the web address at the bottom of this page. That is the address for the organization that promulgated the draft law. And the law has been adopted rather widely throughout the country in all but one state and one territory, the omissions being Pennsylvania and Puerto Rico. So it's very likely that your organization, if you're in the United States, is subject to this law. So what does the law talk about? First of all, it lays out a number of requirements. So these are not optional duties of fiduciaries of nonprofit organizations. These are must-dos. That includes preserving investment funds. I won't go through the whole list, but just to give you a flavor, acting, as Bob said earlier, in a more general way, but specifically with respect to investments, acting in good faith and prudently, and we'll talk a little bit more about prudent behavior in a bit, making reasonable efforts to verify facts that are relevant to decision-making, otherwise known as due diligence, making decisions about investments in the context of an entire portfolio, or what we call in the investment industry, using principles of modern portfolio theory, or MPT. Diversifying investments is critical to proper management of investments. So if I had to pick one thing on this list, it would be diversification as an important requirement. In terms of investment decision-making, excuse me for a minute, I'm going to mute myself. Bob talked about having distractions in the background, and I sure had one, so excuse me. Now, in terms of investment decision-making, again, the items on this list are not optional. The law requires fiduciaries and those responsible for investments to consider all of these factors: economic conditions, the effects of inflation on your investments, the tax consequences. Even though you're all nonprofit, you all represent directly or indirectly nonprofit organizations, some of you have tax consequences to your investment decisions. For example, foundations actually have a modest amount of excise taxes that they must pay. You have to consider investments in the context of what we call in the industry and what the law calls total returns from income and capital gains. So this is a component of modern portfolio theory. Traditionally, I would say before the 1970s, nonprofit organizations, trusts, foundations would think in terms of income only, which is only a minor fraction of total returns, capital gains being the other part. And to operate or manage your investments, ignoring a significant part of returns, we recognize over the last many decades wouldn't make sense. And finally, something that might be of great interest to this audience, MIFA specifically recognizes the role of what I'll call broadly socially responsible investing. That could be program-related investments, mission-related investments, ESG investing, and other goals related to the missions of the organization. Another important aspect of MIFA is considering how much of the resources that you have are spent and how much is reinvested. And by resources here, I mean, of course, the income, the total returns of the portfolio. So you always have a choice how much you can spend, how much you can reinvest. And again, there are a number of factors here that you must consider when making spending decisions and reinvestment decisions. These include the economic and market environment, total returns, the overall resources of your organization, and the goals for an endowment fund, whether the object is to preserve the endowment in perpetuity or to spend it down over some finite period of time. That will definitely color how much you spend and reinvest. An important aspect of MIFA is it recognizes that boards of nonprofit institutions and their investment or finance committees are not necessarily themselves experts in investments. So MIFA recognizes that organizations can delegate their investments or delegate some of the management and decision-making to other parties, firms like ours, which is a registered investment advisor, attorneys, accountants, others who have some expertise to bring to bear. And I'll just say in a very summary way, as a board member or a committee member or a staff member, the organization has an obligation to exercise due diligence when selecting third-party vendors and experts as servants to the organization. And finally, I'll talk about a bit about fiduciary duty. Bob touched on it as well in a broader context. I'll talk about what it means in the context of investments. It means you have to make investment decisions in the best interests of the organization. There are slight nuances to that requirement depending on whether your organization is a corporation or in some cases a charitable trust. So the laws are a little bit different for different types of organizations, but the bottom line is your investment decisions need to be for the benefit of the organization and not for any other purpose. And then importantly, investment decisions need to be prudent. And I'll say in a pithy sort of way that prudence is what prudence does. And the language is very specific in MIFA and other similar laws. Fiduciaries have, I'll read this because it's so important. Fiduciaries have a duty to act in good faith with the care an ordinarily prudent person in a like position would exercise under similar circumstances. So you as a fiduciary, whether you're a board member, a committee member, an officer of an organization, or a staff member responsible for investments, you have a fiduciary duty to be prudent. And what is prudent is a little bit circular. It's what other people do and some other fiduciaries do who are prudent in similar circumstances to yours. So, of course, there's a lot of case history, perhaps as well case law, that defines what prudence is. But as I said at the outset of this subtopic, prudence is what prudence does. So again, it's a little bit circular, but experience and those of your colleagues who are more experienced in these matters can provide guidance about prudent decision-making. At this point, I'll hand it off to Rich Moreland, who will talk about investment policy statements. I will just say under MIFA, you're not required to have a written statement, but it is considered a best practice, and every nonprofit organization is required to have an investment policy, whether it's written or not. So with that, I'll hand it over to Rich.
Many thanks, Matt. I'd just like to say in addition, and thanks for my introduction, Matt, Where I learned the most about investment policy statements was my tenure with Cambridge Associates. When I left the Society National Geographic, I went to Cambridge Associates for a while before going on from there to a money manager. And so I was exposed to a wide range of clients, all nonprofit at Cambridge. Sort of take a reporter's view of the IPS, what, how, and why. So the investment policy statement is really a guide for how an organization is going to invest their long-term, in case of nonprofit, often endowed funds, we'll just call it the fund. It's very important that there's a very, very clear description of the organization, and as important, the role of the investments in the organization's mission. And I saw there's been one question relative to risk. There are at least two key factors that come out of this first, this introduction. And the first is a very, very clear description and understanding of the risk tolerance of the organization. And then the investment horizon of the organization. Matt alluded to it very briefly. There are some nonprofits that set up a wasting endowment. I mean, there's now granted, it's just a very small part of their assets, but you know, the Gates Foundation, their mission, they have many missions. One is to eradicate polio, which is about done according to them, which is great news. And the other is malaria. Well, they will have carved out a section of the endowment for that. It'll be a wasting or a spending endowment. As far as how, we've talked about governance, and under the governance and management of the organization's board of directors and investment committee, investment staff, and often with the aid of an external advisor or consultant, there's all those taken as a whole promulgate the, and next page, Matt. Promulgate the overall investment objectives and spending policy of the organization. Now, the spending policy is oftentimes very straightforward. Probably doesn't apply to any of the audience here, but if there's a PF, a private foundation, it's dictated by law. Now, within a range, you could say that even the nonprofits are dictated as well, because if they don't spend enough, then they'll be hit with an excise tax. So there's a promulgation of this overall investment objective and spending policy, but they also come up with the portfolio investment policies for very specific areas of the management of the fund, the obvious ones being asset allocation, municipal investments, diversification, and rebalancing. And again, Matt alluded to socially responsible investing, and we actually refer to it as sustainable investing, and that's where that would come in under this heading. And under sustainable investing, we put socially responsible investing, ESG, impact, and mission investing. And they all mean very, very different things. Next page. So you get down to monitoring. And as you can see, there are several aspects to this. So you're going to monitor your portfolio holdings as well as individual transactions. And you're going to monitor the overall performance of the fund, but you're also going to monitor the component performance of each manager, of each advisor. And you can also monitor the advisor itself, i.e. the investment consultant, and see how they're doing over the years. And oftentimes there are set times that each has to be monitored at least annually, with a report going to the committee and then up to the board. And then finally, there's a nitty-gritty day-to-day, and it's often done on a monthly and certainly a quarterly and annual basis of reporting and meeting agendas and record keeping. And I would say this actually, although those three things seem like perhaps the most mundane part of the IPS, I would say they actually get to the why, the real why. And done correctly, done well, and maintained well, through its reporting and record keeping functions, the IPS really functions as the organization's collective institutional memory of why the fund was invested as it was and why it's invested it is now. I'm sure on the line we have a wide range of experience. Some of you individuals have probably been at the management or committee or trustee level of nonprofits for many, many years. And it's probably not unusual for somebody on an investment committee who just came onto that committee, and some nonprofits have a really pretty high turnover, to look at the fund and how it's invested and wonder why. You know, let's say emerging markets as an asset class was down 50% last year. They would look at that and they'd say, well, why do we have a 7.5% allocation to emerging markets? And you know, you don't want to be flip and say, well, it seemed like the right thing to do at the time. But if you've maintained the minutes and the iterative decision process that went into building the policy portfolio from the beginning of time, so to speak, to where you are now, and this could be 10 years later, you'll go back and you really see why that allocation to emerging markets took place. And perhaps the risk tolerance and or the time horizon of the fund has changed as well. Oftentimes when organizations get more money, a larger endowment, they actually feel they can take more risk. And if their mission has changed, they might feel they can take more risk. Conversely, they might feel like they have to be much more conservative. And so I'll just conclude by saying, in my opinion, that is the most important goal that a well-crafted investment policy statement serves. And that is to serve as the institutional memory of the organization with respect to how the fund was invested.
Matt, if I may, because something that relates to both your comments and Rich's comments, there's a wonderful quote attributed, well, it is, from the late David Reisman, sociologist at Harvard, who said the role of the board is to protect the university or organization of the future from the actions of the present. And so that applies to your preserving funds, to your objectives for investing, et cetera.
And just to add to that, that's a great comment. And I'm sure you're all familiar with this. And this would come into play in the introduction of the IPS. We often talk about, and especially with respect to colleges and universities, educational endowments, the concept of intergenerational equity.
Yeah.
And that, of course, is for whom does the endowment exist? And the answer is generally it exists for the students that came on campus this week, as well as those in the future.
Right.
Great, thanks, Rich, and thanks, Bob, for your comments. Rachel, I think we're ready for any questions that our audience might have. So if you've been collecting questions, we're all ears.
All right, terrific. Now, there were, I think you answered the question about risk. There were a few very specific ones in the chat functions. This may be better for some one-on-ones. There's a question about sometimes there's a nonprofit that has an endowment that was funded by the original founders of the organization who have since deceased. And the financial statements have not been shared with the remaining board. And they wanted to know, do they have a right to that? This is kind of very fact specific, but any general, have you seen anything like that? The relationship between the board of the organization and the original funders? I guess it depends on how the trust fund or the fund was set up. Go ahead, Rich.
Yeah, like a lot of things in life, there's attorneys. There are attorneys that are sort of all throughout this process. And if I understand the question correctly, there may have been an original deed of trust. And I've run into this with respect to certain sub-endowments. And somebody would pass or there'd be an intervening event, and you'd have to go back to the deed of trust and see really what the original intent was. And in fact, does it still hold true? I don't know if that remotely gets to the answer to that question, but that is why when you're setting one of these things up, or when you're setting up the investment office in general, you really need to go to because we all know that there's the endowment, and then there are all sorts of layers within the endowment. And broadly speaking, we're talking about unrestricted versus restricted spending. And you probably want to find out exactly what legal agreements are behind the restricted funds and whether or not they live in perpetuity. And I'm not an attorney,
Right.
Or whether they can change.
Right.
Yeah.
So to the person who asked the question, go ahead, Matt.
Yeah, let me add to that a little bit. First, Rich mentioned he's not an attorney. None of us on the panel today are attorneys. So I should have said at the outset, don't take anything we say today as legal or tax or accounting advice, because we're not allowed to give it. And we're also not allowed to give investment advice through this particular medium. That has to be in one-on-one under written contracts. So nothing. So it's a long-handed way of saying don't believe anything we say for today. But as to the question, let me just point out, MIFA is very explicit that you're required to follow the donor's intent and the deeds of trust. Although MIFA and presumably the deeds and trust law also have provisions for getting out of, so to speak, getting out from under those restrictions under particular circumstances. So MIFA, for example, talks about when a restricted fund becomes of a de minimis amount, then there are ways to get relief from the restrictions on those funds. And there are other examples that we can give. But as Rich said, you should definitely turn to the attorneys for sound advice on how to deal with restrictions.
But I think the question was whether the board is responsible, and the answer is yes.
Yes.
To get to the bottom of whatever their duties are and the
Correct.
documents have set up. Correct. So have someone help you look at the original documents and figure out what the situation is. Another person asked a question about sort of the other end of the spectrum on sort of imprudent investments rather than being too risky. Could it also fall if investments were so conservative that they weren't taking into account sufficient funds via income or capital gains and maturity relevant to needs of the organization?
Certainly.
Yeah, definitely, yes. And MIFA speaks directly to that. As I mentioned earlier, fiduciaries are required to take into account economic and market conditions, the resources of the institution, the spending rates, inflation. So absolutely, you could have an investment strategy that's too conservative given all of those conditions. You have an obligation at a minimum to generate returns or have resources that cover the spending that is planned for the organization. And in addition to that, if the long-term plans are to preserve the investments in perpetuity, you have an obligation to invest in such a way that you generate enough returns to cover spending for any current year and to cover the effects of inflation on the corpus or principal of the investment. So it would be considered imprudent to be too conservative relative to the circumstances of an organization, just as it would be imprudent to be too risky or too aggressive relative to those circumstances.
And then I think, and again, I think there are real world examples. Matt, maybe you, Bob, you as well. I want to say, I'll go ahead and say the word. I want to say NYU for years had an extraordinarily conservative policy portfolio, mainly driven by one particular family who's a large donor. And it was during an ebullient period in the market, and they really lagged. And I guess the follow-up question would be, so what happens when that happens? For many years, people were very, 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 governance and certainly attorneys, it was hard to bring legal action against the governance structure of a nonprofit. I think the theory was these people are doing the best they can. They're mostly volunteering their time, et cetera, et cetera. I think that's changing. And so, yes, it can be too conservative. It can cause damage. And I think there can be action taken.
I think another couple of questions are very fact-specific against their situation, I would imagine. One had to do with a foundation managing an endowment decides to stop funding the sole beneficiary. The beneficiary challenges the decision. Is the foundation allowed to drag on and pay for legal fees if they have to defend their decision? Have you ever come across a situation where I guess the foundation that holds all the money for a particular beneficiary, meaning a nonprofit organization, has stopped funding?
Well, there's a very famous case, which is the Hershey School.
Yeah, right.
Which is was the beneficiary of the Hershey chocolate founder, left a humongous endowment for the school. It's literally worth billions of dollars, and the sole beneficiary is the school, which has it's a boarding school with, I don't know how many students, but it's measured in dozens, not thousands. Perhaps Bob knows. And that the Hershey School was and is the sole beneficiary of this endowment. So there have been, this doesn't quite get to the question because the issue at hand there was whether it was prudent for the endowment to continue to invest virtually all of its assets in the Hershey Corporation, which is a publicly traded company, or should it diversify? So that's a slightly different case. But in response to the question, there are definitely cases out there where there is a sole beneficiary and there are disputes about what the right thing to do is.
Yeah, and
perhaps my colleagues have other examples.
Yeah, and briefly what happened with Hershey was Milton Hershey and his wife loved children, could have none of their own, and therefore the school came about, and the school to which Matt alludes is for certainly at least indigent young people and orphans. And some of these young people go into school from a very young age, and and they can't bust the trust because, as Matt says, it's solely to help the school. And they've tried. I mean, you can be born into very, very poor circumstances, and if you're bright, you're going to go to that school. And if you get into Yale and then go on to, sorry, you got to give equal time here to Harvard Law School, your entire education is going to be paid for. But even at that, and to Matt's point, you can go to Hershey and drive through the campus of the school, and they live in group homes, and they're beautiful group homes. I mean, they have tried their damnedest to spend as much of this as they can, but they just can, and they can't bust the trust. But if the question was, and something we'll give there, if the question was a question that you just simply stop spending on the mission?
I think the question was, and just to read it, a foundation managing an endowment decides to stop funding the sole beneficiary, citing its variance power, and the beneficiary challenges that decision. Is the foundation allowed to draw on the endowment core to pay for their legal expenses defending their decision?
Yeah, that's a very specific question.
Yeah,
the only sole beneficiary foundations I had experience with wouldn't have had an issue like that. They were like University of Arkansas. There's a foundation whose sole benefit is the university. In the same case, University of Minnesota. That's a very specific legal question, I think.
Yeah, that's what I thought. All right, so let's move on to the next question. Someone mentioned that some large foundations like Ford and others are engaging in debt financing for their grant making. Do you know anything about this novel approach about how they finance and use their assets? I'm not sure if that's
I've read
the right way, but
I've read the letters from Ford as well as the news stories. Several of the large foundations have decided to take advantage of the extraordinarily low interest rates and their credit rating to borrow very large sums of money so as to leverage their strengths to increase their influence through grant making. But it's a the credit worthiness of them and the extraordinarily low interest rates that give them a very long horizon. There are other
And
examples.
Yeah, there are,
And I assume there's also debt limitations on when any endowment or school could, or organization can take on
yeah,
their books.
almost surely within their bylaws and investment policies, they have limitations. I'll just add, without getting into too much, without getting into any detail today, there's a whole other topic, but there are technical reasons within what I'll refer to as modern portfolio theory as to why, from an investment, purely investment perspective, borrowing money against an endowment, for example, actually can make sense in terms of optimizing returns. Bob pretty much touched on how that would work, especially in today's environment where interest rates are so incredibly low, historically low. But it is a risk because at the end of the term of the borrowing, whether it's 10 years or 20 years or 30 years, you either have to refinance it, presumably at higher rates,
Right.
or you have to pay back the principal, which means using your endowment funds to pay off the debt. So there's a risk if interest rates turn against you or the market turns against you while you're in debt.
And I don't know if this applies, but it's strictly in the endowment area. People used to, college university endowments used to borrow money at a certain rate and then try and arbitrage it. So they borrowed a low rate and they invest it to try and make more money. And that, some years ago, that was brought to a halt. To borrow money now, you have to tie it to an asset on the balance sheet. So the obvious thing is to build a new dormitory or something like
Right.
that. But I don't know if this remotely is in the question, but you can't borrow, a college or university endowment can't borrow to arbitrage and borrow low and try and make money from it. They have to be borrowing for a reason. And Bob, you would clearly know more about this than I.
Yeah.
Okay, thank you. Go ahead, Bob.
Yeah, I saw a question about whether the principles of governance that I outlined apply to for-profit enterprises, and the answer is yes. In fact, one of the reviewers of my book gave a great blurb, is Ira Milstein, who's the Dean of Corporate Governance. The principles apply.
One other question that someone's asked a few times I want to make sure we address is about D&O liability insurance. Is it required? How much? I think there was just a general one thing we didn't talk about with respect to failure to meet fiduciary duties, et cetera.
Right. I had a reference on the slide, but I didn't elaborate. Yes, and the amount of such D&O insurance should be a matter of legal advice. We see examples. Well, I'll give an example of Delphi University when in 1997, following a suit that went from the Attorney General's office to the Board of Regents that held hearings, the members of the board of the private university had to pay amounts in the hundreds of thousands of dollars because the actions were not covered by the D&O insurance. Actions including excessive compensation for the president and conflicts of interest in business dealings between board members and the university. Again, not covered by the D&O insurance. So yes, it is important to have D&O insurance.
Yeah, I'll just add, I don't know that it's required under the law, but Bob implicitly, I think, would agree with the following comment. I personally would not serve as an officer, director, or committee member of any organization, whether for-profit or nonprofit, without knowing in advance that the D&O insurance was in place.
It refers back to your comment about prudent behavior.
Correct. And for the person aware to get these, there are many resources, National Council of Nonprofits, et cetera, legal organizations that provide. Sometimes they have vendors listed. Most insurance brokers will specialize in this, and that's a question for the board and whoever is delegated to do this, to find out a policy that works for your organization, number of people, size of your endowment, et cetera. It's pretty fact specific. It's not that expensive, but it is, one of the first expenses most nonprofits need to engage in, I think. One question.
Let me give you one more
Yep.
example. I was on the board of an organization that served children. And goodness knows, I mean, not to bring up an ugly topic, but when children are involved, then you have their personal safety at stake. And you just never know when someone involved with the organization is going to do something abusive toward a child, whether verbally or physically or otherwise. And as fiduciaries of an organization, you're responsible for that. Right. I wouldn't serve such an organization without the proper protections in place for my personal benefit, but also for the benefit of the organization.
Yep. I recall maybe a couple of years ago, there was a case that came out of one of the boarding schools where a girl picked up a strange infectious disease in China or someplace, and she'd gone off the path that you were supposed to be on, was debilitated after that, and it was like a $40 million judgment, and every board that I knew of was sort of like, oh my God, do we have enough liability insurance? This is not D&O insurance, but it kind of goes into the sense of what is the fiduciary duty of the board, whether it's the investment committee or it could be the governance and policy committee, to think about, are we adequately protected given, as you mentioned, K-12 schools? I mean, unfortunately, there is a business out there of people giving advice, because it happens all the time and you never know what's going to come up, and there could be huge settlements. So much trickier when you're in the K-12 or dealing with children, as you said, if it's direct service.
Yeah. And one chilling point, somebody mentioned how much should you carry? And again, I'm not an attorney, and so I don't know about the personal liability, but a place to start is the amount of the endowment.
Mm-hmm.
Yeah.
So if you got a $50 million endowment, and to Matt's point, there's some potential liability, that's a place to start. Now, again, I'm sure if it's gross negligence, then they can go from there to the individual's personal wealth.
Have good insurance, have good bylaws, have a good composition of your board. I know we didn't talk about that as much detail, but when you're bringing board members on, make sure you've got a good policy, good vetting, good balance, good expertise.
Yep.
I have one, go ahead. Then I have one last question.
No, you're.
So one thing I just wanted to hit on before we close out is many people in our community are small nonprofits with very small endowments. At what point should they create an investment committee and a policy and start funding? A lot of us are in these sort of annual cash bases and just, maybe a couple $1,000 sitting in a, savings account or something. What's your experience for when and how they should start setting this up?
Yeah, let me speak to that, because I looked into that specifically, that specific point. Under MIFA, what is considered an investment fund is actually defined. So I'll suggest that people look to the specific language and the definitions in MIFA. But it's clear that, for example, the situation, Rachel, that you just mentioned is not an investment. Let's say it's a checking account that you use for day-to-day expenditures for your charitable purposes. That is not considered an investment. However, if you have, say, $1,000 in a money market fund and you don't intend to spend it, but you intend to generate returns from it, that is an investment. So there's no number attached to the requirements. As soon as you have any amount that's intended for investments and not intended for day-to-day spending, it is an investment and you are required to follow MIFA. So I would say don't put $1,000 into a mutual fund or something and call it an investment, because then it creates this whole
the question was, when do people start thinking about this? If you're otherwise getting cash in, cash out on a kind of annual basis, is if you want to think about, gosh, this is not how we want to live. We want to start building an account, how do we start that? You know?
Yeah,
And do we-
and
you
the
know, it's like-
answer, yeah, and my
Have an
answer is,
investment
my
policy
answer
before
is,
you have an endowment.
yeah, and this is why Matt and I are never going to retire multimillionaires. And I know this is not remotely a commercial, but the answer is use your common sense, and let's pick a number. Let's say you're up to one to three to even $5 million. Well, any advisor, I know we do, but any advisor worth their salt will work on a fee-only basis. And so you can have somebody for just a very few hundred, maybe, you know, $2,000, $3,000, $4,000, $5,000 a year. Look at that $3 million and say, here's Vanguard Investments website. Go there, put it in a well-diversified passive asset allocation account. So, like Matt said, the answer is probably no amount is too small, but use your common sense with how much you pay for the advice.
Mm-hmm, mm-hmm. And obviously part of the issue is, you know, people are thinking about is if you want to be able to accept non-cash donations, you need a place to put that. But that's part of, if you want to start growing your organization and you want to make that flexible, and if all you have is a cash-based system, you can't grow.
Yeah, and not only that, any donor with their salt, and this is generally to the larger donors, will ask you, you know, let's say they're considering a high six or even a 7, 8 figure, certainly that. They'll ask you if they can speak with your governance vis-a-vis investments, and they'll want to even maybe speak with your investment consultant, and they'll want to see your investment policy statement, because if they're going to give you $1 million, they want to make sure it's being invested well.
Exactly. And the ability to accept different kinds of places and make sure it's invested.
Yeah.
All right. We are at the end of our hour. I appreciate, gentlemen, all the expertise you've shared with us. Thank you for sharing your information. I'm sure people will be in touch with you. Hopefully you get a bunch of requests after this. Just to repeat to everyone on the call, we have recorded this, so we'll have it cleaned up and sent out with a link to our everyone who registered for this program, and then we save it on our YouTube channel. We also have the ability now to strip out audio portions so you can listen to it as a podcast if you wish, and you're tired of looking at a screen. A lot of people have requested the slides as our policy. We provide the deck and materials that are used in these kinds of programs to those who are what we used to call paid members. It's really people who are donors to YANA at the minimal $60 a year. So if you'd like to get access to these materials and some of the other ones where we have various sort of technical information with presentations like this, please go to our website, yana.community, and there's a little button on the top that says donate, and you can support us there. But thank you for joining us. Rich, Bob, and Matt, thank you again. I'm sure you're going to get follow-up questions. I'm already thinking of other questions. So
yeah, thank you for having
thank you
us.
everyone for joining us. Have a wonderful day.
Thank you.
So
Take
long.
care. Bye-bye.